By the time the U.S. Supreme Court banned the death penalty in cases of adult rape in 1977, Thurgood Marshall had been a justice on the court for 10 years. He wrote a brief concurrence in the case, Coker v. Georgia, citing his opposition to the death penalty, which then as now disproportionately targeted African American men. Marshall's experience with capital rape cases, and specifically with cases of black men accused of raping white women, was uniquely deep. For while the later decades of his career found Marshall enrobed as the country's first African American Supreme Court justice, in his early years he had virtually lived from a suitcase, crossing the country as an activist lawyer, known for defending innocent black men from a system of white justice that craved their freedom and their blood. Of the 455 men executed for rape between 1930 and 1972, 405 were African American. Marshall had noted in a separate court decision, were it not for him, the number would have been even higher. As a lead lawyer for the National Association for the Advancement of Colored People, NAACP, beginning in the late 1930s, Marshall would leave his home in Harlem, get a train from Pennsylvania Station and ride for days into hostile territory: Oklahoma, Florida, Texas, Tennessee. His calling, and the NAACP was flooded with calls, was to defend against criminal charges and to represent plaintiffs in segregation, equal pay and voting rights cases. He had to do things that, if he did them outside of court, it would have gotten him killed. Kenneth W Mack In some criminal cases, Marshall might be able to win a life sentence instead of execution. In rare cases, he might win a not guilty verdict. By the late 1940s, he was logging an estimated 50,000 miles a year, according to Gilbert King, whose Pulitzer-winning Devil in the Grove tells the story of Marshall's defense of an infamous 1948 Florida rape case. The places he was going were places where there weren't any other lawyers who were going to do this work, said Kenneth W Mack, a Harvard Law School professor who wrote Representing the Race, The Creation of the Civil Rights Lawyer. There were also places where almost nobody had ever seen a black lawyer before, and he had to do things like challenge the local practices of segregation, come into a courtroom, call white people as witnesses, cross-examine them. He had to do things that, if he did them outside of court, it would have gotten him killed.